Hi class, as you'll recall, we went through a quiz in class the last time we met, and what I'd like to do is go through that one more time as you prepare for the exam. Just remember that the National Labor Relations Act only applies to private employers, okay, because you're going to be asked that on the exam. Excuse me if I look down here, but I'm looking at the quiz to make sure that I follow it accordingly. Does the NLRA protect employees even if they're not in the union? And the answer to that is yes. If they're involved in concerted activity for mutual aid and protection, they're covered by the Act. So the answer there is yes. Number 2, explain your answer. I just did that. Number 3, how many employees have to vote for a union if there's a union election? And it's 51% of those voting, not 51% of those in the union who are going to be in the union, but 51% of those 51% of those that vote. Next is, what does the National Labor Relations Act say in regard to Section 7? Well, Section 7 allows for unions, or you don't have to be in a union. It allows for bargaining, and it provides that folks that are involved in concerted activity for mutual aid and protection are protected by the National Labor Relations Act. Number 5, the question was, were Najib and Amanda engaged in concerted activity? And yes, they were. What they told the employer was, hey, if our work conditions don't improve, then in fact we're going to form a union. Number 6 is whether or not the employer engaged in anti-union animus. Remember that anti-union animus is simply discrimination based on union status or lack of union status. And in this situation, they were fired really because of the fact that the employer did not want a union. Number 7, the question is about Facebook. Can an employer terminate someone based on the fact that they've said something about the company on Facebook? It depends. The National Labor Relations Act protects folks on Facebook who are saying things like, you know, I wish our hours were better, I wish our wages were better, I wish our working conditions were better. However, if they're saying nasty things about the company, which in fact could damage the company's reputation, like we sell nasty meat and it's not true, or somebody is, I won't go into details, but it's an untrue statement about a supervisor that damages the company and the supervisor, in that situation I would say yes. So it depends on the conditions, and it also depends on the content. Next is, they've signed an arbitration agreement, they're at-will employees. Do they have to then go to arbitration? I think so, but at the same time, like I told you in class, the NLRB could bring their own claim of a violation of Section 7, and that would not have to go to arbitration. That would go through the National Labor Relations Act and the National Labor Relations Board. Number 9. Mandatory subjects of bargaining versus non. Mandatory subjects of bargaining are wages, hours, terms and conditions of employment. Non-mandatory subjects of bargaining would be like, what should we sell? What should we make? How should we make it? Those are decisions that are to be made by the employer. Why do we care? Because you can only force the other side to bargain to impasse over mandatory subjects of bargaining, not non. Okay, only impasse. You can only bargain to impasse over mandatory subjects of bargaining. Now, number 10, whether or not, it says here, the National Labor Relations Board can put these two employees back to work, and the answer is yes. If in fact they find that they were involved in a concerted activity for mutual aid and protection, even though they're not in a union, the National Labor Relations Board has the authority to put them back. Thank you very much.